This week, states have been piling on against Kalshi. They've already been hit with cease and desist orders in 6 states, and on Wednesday, a federal judge in Maryland held a teleconference in Kalshi's lawsuit to block the state from enforcing its cease and desist orders. While Maryland's temporarily holding off on enforcement pending the judge's ruling, the regulators there still claim that Kalshi is offering illegal sports betting. While that's going on, New Jersey filed a blistering legal brief opposing Kalshi's attempt to avoid enforcement. They're claiming that even under the Commodity Exchange Act, states still have the power to regulate things like gaming. There's no preemption. So what does that mean exactly? There are certain products, namely futures, that are 100% within the CFTC's jurisdiction and no one else. There's called preemption. No other state and no other federal regulator can regulate those transactions. Years ago, there was a lawsuit regarding a product called index participations that the CFTC thought they had jurisdiction over. Whenever you have a contract, you have two sides, a short and a long, and on one side it looked like a future, and on the other side it looked like a securities, and the SEC thought they could regulate this, but the court said no on these index participation. If one side looks like a future, one side looks like a security, CFTC has exclusive jurisdiction over that, preemption. So what does that have to do with states? Well, there's certain products where we don't have 100% preemption. For instance, foreign currency. In foreign currency, not only does the CFTC get to regulate it, banks get to regulate it, states get to regulate it. There's no federal preemption for that. And they claim that this is one of those areas, gambling, that the CFTC does not have preemption and the states can get involved. There's another problem that no one else is talking about at all, and that's, does the CFTC have authority to approve these exchanges to begin with? So what do I mean by that? The CFTC has the authority to regulate exchanges and approve exchanges that deal with contracts for future delivery and other things like that, but they have to be in the statute. The CFTC can't approve exchanges on things that are not within their jurisdiction. Just like the SEC did not have the power to regulate index participations because they weren't within their jurisdiction, the CFTC can't approve exchanges on things that are not within their jurisdiction. The CFTC thinks event markets are within their jurisdiction, and that's why they approved it, but the thinking on that is not unanimous. And on the initial rule that approved these exchanges, it wasn't a unanimous vote, and the dissenting commissioner had made this argument that they didn't think that the CFTC had jurisdiction over event markets. Does that matter if the CFTC thinks they have jurisdiction and other people don't? It does matter because recently Chevron was overturned. So Chevron is a case. Recently, the U.S. Supreme Court overturned the concept of Chevron deference in interpreting statutes and regulations. So Chevron deference was the concept that when you're dealing with a complicated statute like the tax code or the Commodity Exchange Act or ERISA, and you have a specialized agency that deals specifically in that area, that if there's an ambiguousness in the statute or the rules, that the court will defer to that agency's interpretation of that ambiguity because they are experts in that. And there were limits to that even under Chevron because if the statute was not ambiguous, then the court would not defer to their interpretation, and the interpretation had to be based on sort of solid legal footing. So if the agency kept changing their mind on what they thought something meant, then they wouldn't get that Chevron deference. But in general, the agency would generally get Chevron deference. However, that was overturned this year with a Supreme Court ruling. And now it doesn't really matter what the CFTC thinks the statute says. It matters what the judge says. So if the CFTC thinks they have legal authority to approve exchanges where they can offer trading on sports betting and things like that, if a judge says that's not in the statute, it doesn't matter what you think. It matters what the judges think because you don't get Chevron deference anymore. Start with first principles. If you have the authority to approve exchanges that allow the trading of commodities for future delivery, what is a commodity? 1A9 of the Commodity Exchange Act defines what a commodity is, and it says in relevant part that it's, quote, all other goods and articles and all services, rights, and interests in which contracts for future delivery are presently or in the future dealt in. So is the outcome of a football game, is the outcome of a soccer game, is that something in which a contract for future delivery is dealt in? You're not delivering anything there. It's just an event, just like whether it rains or not. It's not a contract for future delivery, because contract for future delivery deal in goods, services, articles, rights between two parties. So just like in the index participations case where the court said to the SEC, you don't have jurisdiction over this, the court could say to the CFTC, you don't have jurisdiction over this and you can't allow Kalshi to trade these as a designated exchange. And this is something that should be regulated by the states. And the states will not allow you to trade this as an exchange rather than as a casino. And whether the CFTC thinks that they have jurisdiction to allow this trading is irrelevant because they don't get Chevron deference anymore. And it's important to remember that when you deal with something like a financial product traded on an exchange or an insurance contract, it's different from betting on sports because there's an economic purpose for having insurance or trading something on an exchange, and there's no economic purpose to a sports outcome. And you can't say, well, betting on the sport creates the economic interest in it because in insurance contract, you have something called an insurable interest. So I can take out an insurance policy on my life. My wife can take out an insurance policy on my life because she has an insurable interest in my life, and so do I. But my neighbor can't take out an insurance policy on my life. He can't take out a firearm policy on my life because then you're speculating on the outcome of something that's not within your control or something that doesn't affect you. So states don't allow that because you don't have an insurable interest in that outcome. And you betting on that cannot create the insurable interest so that you have an insurance contract on that. And the law on this goes back for as far as the US goes back. And that's why in Europe you have a lot of trading in things called contract for differences, and you don't have them in the US because in the US contracts for difference are illegal because unless you have an economic interest in the outcome of something, then just betting on that is pure speculation, and the law despises speculators. And there's a law professor at Georgetown, his name is Lynn Stout, who wrote a lot about speculation in the financial markets. And one of her papers, I believe, is Why the Law Hates Speculators, where she goes into great detail on the law about this and why it's a certain way and not another. And actually, when I graduated and I wrote a paper on the Commodity Futures Modernization Act, she was one of the people who I showed my paper to, and she gave me some very helpful suggestions. So if you want to learn more about that, you can check out her law review articles. There's a lot of case law on when contracts are insurance or hedging versus just speculation, and contracts for difference, and when they fall into one basket and not the other. The classic case is Irvin versus Villiar in the 1800s, and that went all the way to the Supreme Court, and it said contracts for difference are speculative, they're gambling, and that's why they're not enforceable under public policy and public interest. So if you think Kalshi can win against all these state regulators claiming this is illegal gambling, you have to believe certain things. You have to believe that the CFTC has the authority to regulate these things. You have to believe that they're not gambling. You have to believe that the definition of a commodity in the Commodity Exchange Act includes the outcome of a sports event, and that is some type of contract for future delivery that is contemplated by the Commodity Exchange Act. You have to believe that it is 100% preempted by the Commodity Exchange Act, and that the CFTC has the authority to regulate this and states do not. So you have to buy all those things, and all those dominoes have to be in a row for you to win. And also you have to keep in mind that Chevron deference has been overturned. So even if you think this and the CFTC think this, the court might not think this, and it is the court's opinion that matters. And even if you think this, the CFTC thinks this, and your law firm who you're paying thinks this, that might not be the right answer because, as I said, it always depends on what the judge thinks. And if you go through Supreme Court case law, you'll find a lot of them that are 5-4. So partners at your law firm was on the Supreme Court, which is not allowed. and you ask that partner, what do you think of this? In a lot of the cases that went all the way to Supreme Court, half the people you ask will give you the wrong answer. So just something to think about. Anyway, my name's Pete, and I'm a financial lawyer with 25 years experience in the financial markets. I started in mergers and acquisitions. I worked in the largest merger in the world. I spent 20 years as a financial regulator working on futures, options, hedge funds, FX, you name it. And I started making these videos for fun. And if you have any questions about the Commodity Exchange Act or any other financial topic, just leave it in the comments. If there's a video that you'd like to see, or if you'd like to talk to me personally about something, just drop a comment and I'll figure out a way to get in touch with you. And I should add a disclaimer that I'm a lawyer, but I'm not your lawyer. And anything you see here is not legal advice in any way and does not constitute an attorney-client. And nothing here creates an attorney-client relationship. So this is all for informational and entertainment purposes only. If you have specific questions about how your specific circumstances relate to the law, you should speak to your own legal counsel. That's not me. So anyway, like and subscribe, and I'd love to hear from you if you have any questions about this. Put them in the comments.